Let me just continue, and as I indicated in my opening statement, at the request of the National Nuclear Security Administration, the Department of Energy IG reviewed certain consulting agreements awarded to Heather Wilson and Company, LLC, whether they were appropriately administered and managed, and essentially that was a sole proprietorship, as I understand. Two significant issues were identified in this review. It appears that you may have charged as many as 4 different government-owned and contracted operated sites for the same consulting services for which you received approximately $450,000. The IG noted that under the Federal Acquisition Regulation, fees for services rendered are allowable only when supported by evidence of the nature and scope of the service provided. The IG concluded that you did not comply with this requirement, nor was it enforced by the contracting official involved. And while the contracting official did not enforce the Federal Acquisition Regulation contract, were you aware of the requirements to provide evidence supporting your 50 hours of work for $10,000 a month for Sandia and Los Alamos?
Senator, I did the work. I complied with the contract. The review found no fault with me, and the DOE auditors never even talked to me.
But were you aware, my question is, the need to maintain work product and evidence of your work,
Senator,
simply for accounting
submitted
purposes?
substantial work product and worked directly for the laboratories for no less than 50 hours a month.
Do you have records showing that you were spending 50 hours a month doing that?
Senator, if the DOE auditors had bothered to talk to me, I would have been able to help them with that when this matter occurred 7 years ago now.
So your position is that you had no knowledge of the requirement to maintain records and that whatever records you acquired are no longer in your possession?
Senator, I complied with the contract and provided the work that the Sandia National Laboratory and the other laboratories asked of me.
Did versions of those contracts contain language requiring record keeping, and did you reject those versions of the contract before you signed it?
Senator, I don't believe so. I don't recall anything like that.
So you don't recall drafts of contracts that were offered to you that required, according to FAR regulations, that you would maintain records of your work so that they could be validated? You don't recall that?
Senator, the contracts that I signed were pretty standard contracts provided by Sandia and Los Alamos and so forth.
Did you review contracts before you signed the final contract and made comments?
Yes, Senator.
So there was a negotiation about what would be in the contract and would not be in the contract?
Senator, mostly with respect to the statement of work, yes.
And in that negotiation, did you cause or agree to the deletion of the requirement to maintain records at all?
I don't recall that at all, sir.
Okay. Just let me ask a question which is much more pertinent today, which would be if you, as Secretary of the Air Force, discovered a invoice paid by a laboratory on your management which simply said consulting services 8/1/2010 to 8/30/2010, $10,000, would you accept that?
Senator, I would expect the people who are managing that contract to manage it well. In this case, I was in very close contact with the people at Sandia. They knew exactly what I was doing. We worked often several times a week together on things that they wanted me to do. I fully complied with the contract, and I did the work.
Why would the Lockheed reimburse the government $442,000 or more for work which the government could not find, nor could the Lockheed find evidence, and not try to reimburse or ask you to reimburse monies?
Senator, you would have to ask Sandia that.
So if you were Secretary of the Air Force, you would not probe down to the actual contractor, the subcontractor, to determine what was done and see if they were culpable for anything?
Senator, as I understand it, at least initially, Sandia rejected the conclusions of the Department of Energy audit as well.
Let me shift quickly to, in 2008, a report of the Department of Justice indicated that you contacted David Iglesias, the U.S. Attorney for New Mexico, to inquire about the prosecution of certain public corruption cases. The House's ethics manual, in effect at the time, provided that a request for background information or a status report from federal attorney, quote, may in effect be an indirect or subtle effort to influence the substantive outcome of the proceedings, close quote, and further states that the best way to communicate is in writing and make it part of the proceedings. Why did you call Mr. Iglesias about the public corruption cases?
Senator, let me correct one of your assumptions there. I did not call him about particular cases or any particular person. And this matter was reviewed by two independent groups, both the Department of Justice and the House Ethics Committee. The House Ethics Committee interviewed Mr. Iglesias and chose not to even start an investigation of me. With respect to why I called him, it's because public corruption was a serious problem in the state of New Mexico, and an individual, a constituent with knowledge of ongoing investigations, told me that the U.S. attorney was intentionally delaying corruption prosecutions. And I felt as though I had to address that allegation in some appropriate way.
Now, so you did not call him about corruption cases specifically, but you called him about corruption cases, which I think logically people would infer, or he would infer, were those cases that were pending before his federal attorney's office. Is that a fair assumption?
Senator, sadly, there at the time were a very large problem with public corruption in New Mexico and a large number of investigations underway.
You said you called in response to an inquiry by someone. Who was that person?
Senator, someone trusted me to do the right thing with information that concerned them, and I didn't betray them then, and I'm not going to betray them now.
Well, I think it's important because it adds to sort of the motivation for the call. If this was a random constituent, that's one factor. If this was someone who had an issue or a motive to bring the cases or not bring the cases, that would, I think, cast this call in a much different light. So I think it's very unhelpful to not be able to indicate. If this was an innocuous call about the general status of prosecution in the state of your home state, prompted by an innocuous contact by someone, I don't see why you would be reluctant to indicate who urged you to call.
Senator, I didn't betray them then, and I'm not going to betray them now. I do think that the issue here, and you and I come from a very similar background. You came from West Point, and I came from the Air Force Academy, that one of the appropriate ways to resolve an allegation of impropriety is to talk to someone about it. That's what I did with David Iglesias, who was a personal friend. He gave me his word, and I took him at his word.
So that you are called a federal official in his federal role to make an inquiry about pending cases, maybe not specifically, based on an anonymous contact that you received?
It was not about, Senator, I called him to resolve an allegation of impropriety made against him. You and I both know that in some ways, ethically, the most difficult questions to ask yourself or to deal with are not about what you do as a person, but whether you tolerate other behavior. And I had an allegation that the U.S. attorney was intentionally delaying corruption prosecutions. In some way, I had to resolve that, and I chose to resolve it by calling him and asking about it. He denied it, and I took him at his word.
Well, I find it still very unsettling. Thank you. Senator Inhofe.
Yeah.